Hello everybody and welcome to Education Bite number 105, dated November 8th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Education Bite, is entitled The Appellate Jurisdiction of the U.S. Supreme Court. The U.S. Supreme Court, as we already know via History Bite 104, possesses both original and appellate jurisdiction. Appellate jurisdiction requires that the court hear cases that have already been adjudicated in another court first, before being appealed to the United States Supreme Court. It is through the appellate jurisdiction that the Supreme Court exercises roughly 97% of its total jurisdiction in general, and it is also through its appellate jurisdiction that the court performs its primary constitutional role in being the final arbiter on the meaning of the Constitution and other federal law. Through its appellate jurisdiction, the court will indeed exercise its judicial review powers and often strike down federal laws and state laws which conflict with the U.S. Constitution, as well as state or regulatory laws which conflict with federal laws and or the Constitution. Remembering federal judicial power as outlined in the U.S. Constitution, we once again turn to Article 3, Section 2, Clause 1, which reads that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between citizens of different states, between citizens of the same state, claiming lands under grants of different states. Now, certain things in here have been amended by the 11th Amendment to the Constitution, and other things which I omitted are parts of the court's original jurisdiction, which we covered in video 104. So now we skip down to Clause 2 of Section 2 of Article 3, which reads that in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Remember, we covered this in video 104. So, if you want more explanation on the court's original jurisdiction, please watch video 104, The section continues that in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, under such regulations as the Congress shall make. So, in all the other cases before mentioned, that's everything virtually that we covered in Clause 1, The Supreme Court has, appellate jurisdiction only, We covered what it has original jurisdiction over, but everything else, appellate jurisdiction, And Congress is given the authority to regulate that appellate jurisdiction, which it has most certainly done, folks. So, with that in mind, let's go over to where it is regulated, You can find this information in Title 28 of the U.S. Code, Part 4, Chapter 81, which discusses the Supreme Court and its jurisdiction, both original and appellate, Specifically, Sections 1253, 1254, 1257, 1258, 1259, and 1260. Beginning with 1253. This covers direct appeals from decisions of 3-judge district courts. It reads as follows. Except as otherwise provided by law, any party may appeal to the U.S. Supreme Court from an order granting or denying, after notice and hearing, an interlocutory or permanent injunction in any civil action, suit, or proceeding required by an act of Congress to be heard and determined by a district court of 3 judges. 3-judge district courts are very rare. Only certain types of cases are allowed to have a 3-judge district court decide them. And this section simply states that unless otherwise provided by law, okay, if your case is heard by a 3-judge district court panel, you have an automatic right to appeal to the U.S. Supreme Court, okay? Doesn't mean they're going to take the case, but you have the right to appeal to the Supreme Court directly from this 3-judge district court without having to go through a U.S. Court of Appeals first, okay? Simple? Exactly. So now we move on to Section 1254, which covers the U.S. Courts of Appeals, all right? Courts of Appeals, certiorari, and certified questions, okay? It reads as follows. Cases in the Courts of Appeals may be reviewed by the Supreme Court by the following methods. Number 1, by writ of certiorari, granted upon the petition of any party to any civil or criminal case before or after rendition of judgment or decree. Number 2, by certification at any time by a court of appeals of any question of law in any civil or criminal case as to which instructions are desired, and upon such certification, the Supreme Court may give binding instructions or require the entire record be sent up for decision of the entire matter in controversy, okay? So, a writ of certiorari, okay, is the means of appeal to the U.S. Supreme Court. The writ is asking the Supreme Court, okay, to certify, to review and certify an area of law that is in dispute, okay? Obviously, in the lower court, you disagreed. You felt they interpreted the law incorrectly, all right? And you want the Supreme Court to correct this error. And the writ of certiorari says, Supreme Court, please review this case and correct the law that this lower court has apparently interpreted in an incorrect format, okay? And this section thus gives one the specific directions and instructions, okay, which is pretty open to appeal to the U.S. Supreme Court from one of the U.S. Courts of Appeals. Number 1 gives them virtually the right to appeal almost automatically from a U.S. Court of Appeals. All right, again, doesn't mean the court is going to take it, but, okay, once the U.S. Court of Appeals has made their decision, by petition of any party in a civil or criminal case, once the Court of Appeals has made their decision, you can petition for a writ of certiorari to the U.S. Supreme Court for them to review the case. All right. And it is through this avenue, actually, that the vast majority of Supreme Court cases are heard by way of writ of certiorari from one of the U.S. Courts of Appeals. All right. As they sit directly below the Supreme Court in the federal system, this is where the vast majority of the Supreme Court's total docket period comes from. Okay. U.S. Courts of Appeals. So now we move on to Section 1257, state courts, all right? State courts and certiorari. This reads accordingly, A, final judgments or decrees rendered by the highest court of a state in which a decision could be had, all right, may be reviewed by the Supreme Court by writ of certiorari where the validity of a treaty or statute of the United States is drawn in question, or where the validity of a statute of any state is drawn in question on the ground of its being repugnant to the Constitution, treaties, or laws of the United States, or where any title, right, privilege, or immunity is specifically set up or claimed under the Constitution, or the treaties or statutes of, or any commission held, or authority exercised under the United States, okay? B, for the purposes of this section, the term highest court of a state includes the District of Columbia Court of Appeals, all right? So this is the empowerment section for those taking appeal to the U.S. Supreme Court via a writ of certiorari from a state Supreme Court or the highest court of the District of Columbia, known as the District of Columbia Court of Appeals. Pretty straightforward, virtually almost saying the same thing, where there is a law in question, okay? Conflict with state law conflicting with federal law, all right? Or any question, period, with a state law, state constitution, so forth, conflicting with any form of federal law. The Constitution, an act of Congress, a treaty, anything, providing it provides you to be able to file writ of certiorari for the Supreme Court to hear your case from a state Supreme Court, all right? Section 1258, the Supreme Court of Puerto Rico. Puerto Rico, all right? Certiorari, okay? It reads, final judgments or decrees rendered by the Supreme Court of the Commonwealth of Puerto Rico may be reviewed by the Supreme Court by a writ of certiorari where the validity of a treaty or statute of the United States is drawn in question, or where the validity of a statute of the Commonwealth of Puerto Rico is drawn in question, or on the ground of its being repugnant to the Constitution, treaties, or laws of the United States, or where any title, right, privilege, or immunity is specifically set up or claimed under the Constitution, or the treaties or statutes of, or any commission held or authority exercised under the United States. So essentially, that's almost analogous to appealing it from a state Supreme Court. All right. Section 1259 is for the Court of Appeals for the Armed Forces, a very specialized Article 1 federal court. All right. This section reads as follows. Decisions of the United States Court of Appeals for the Armed Forces, obviously dealing with the U.S. Military law, okay, the military code, like I said, very specific Article 1 federal court, may be reviewed by the Supreme Court by a writ of certiorari in the following cases. Cases reviewed by the Court of Appeals for the Armed Forces under Section 867A1 of Title 10. Cases certified to the Court of Appeals for the Armed Forces by the Judge Advocate General under Section 867A2 of Title 10. Cases in which the Court of Appeals for the Armed Forces granted a petition for review under Section 867A3 of Title 10. And cases other than those described in paragraphs 1, 2, and 3 of this subsection in which the Court of Appeals for the Armed Forces granted relief. Okay, so that's the U.S. Court of Appeals for the Armed Forces. And last but not least, Section 1260 covers the Supreme Court of the Virgin Islands. Certiorari from that body. Final judgments or decrees rendered by the Supreme Court of the Virgin Islands may be reviewed by the Supreme Court by a writ of certiorari where the validity of a treaty or statute of the United States is drawn into question, or where the validity of a statute of the Virgin Islands is drawn into question on the ground of its being repugnant to the Constitution, treaties, or laws of the United States, or where any title, right, privilege, or immunity is specifically set up or claimed under the Constitution of, or the treaties or statutes of, or any commission held or authority exercised under the United States. Okay, so it is through these sections, all right, sections 12, 53, 54, 57, 58, 59, and 60, that the appellate jurisdiction to the U.S. Supreme Court is regulated by the Congress. All right. That pretty much covers it all. I think that was pretty comprehensive in truth. All right. And so to briefly recap this, it is via a writ of certiorari, okay, which is the formal manner of appealing a case to the U.S. Supreme Court. Okay. A writ of certiorari asks the Supreme Court to review a case from the lower court and certify essentially an area of law in dispute. By certify, pass judgment upon the case itself, all right, by way of one of its opinions of the court, all right. Court doesn't necessarily have to write an opinion. It could simply say reversed, all right, or affirmed, all right. But in any case, you're asking the court to review the case and give their judicial opinion on whether or not the lower court has correctly interpreted the law via a writ of certiorari, a writ to review and certify an area of law in dispute from the lower court. Okay, the petition for writ of certiorari is taken by one of the parties asking the court to give its final determination on the area of law in dispute, okay, by that party itself who is essentially taking the appeal. All right, so that about covers and wraps up the Supreme Court's appellate jurisdiction. If you have any questions or controversies, please leave them down below and I'll be happy to answer them. Take care, stay safe out there, and if you have not subscribed to my YouTube channel, I humbly ask that you do so. It would be most appreciated. Have a great day, and I'll talk to you at the next Education Bite. Peace.